Okay, class, we're starting with Chapter 21 here, dealing with employment discrimination, which is a good follow-up to Chapter 20, which dealt with employment law. And we talked about, in Chapter 20, the main concept is the concept of employment at will, and that is that an employer can terminate a person at any time for any reason. And we stated that there were two exceptions to those. One is where you have a contract that provides otherwise, or where there's a statute. So Chapter 21 basically gets into those statutes that provide protection to workers from discrimination. Okay, so before we talk about slide number 1, which we kind of already talked about, let me mention something about discrimination. Okay, when I use the word discrimination in this context, it's a term of art. And we've talked before about what a term of art is. Okay, so discrimination in everyday terms means I can discriminate between the two chairs in this room, which means what is the difference between them, or treating them differently. But in the term of art discrimination, in the legal context, it means discrimination that is normally considered to be illegal, which means it has to relate to certain classifications like race, religion, and we'll get more into that in a minute. Okay, so again, the exceptions to the at-will doctrine. Okay, so in order to be protected from this type of discrimination, one has to fall into a protected class or classification. Okay, so what are the classes that are generally protected? Race, color, religion, national origin, and gender. And there are a few others that have some limited protection, perhaps. Okay, so whenever you are doing taking a look at discrimination, think of two circles. In one circle is one class, in the other circle is another class. Okay? So in one circle, if we're talking about race, would be blacks, in another circle would be whites. And the discrimination is because the people in that circle containing the blacks are being treated differently than the people in the circle containing the whites. So that's a good way to set up a system of looking at how we look at discrimination in that situation. So, what are the laws that protect one against discrimination? Remember that the Constitution itself perhaps prevents discrimination, such as under the 14th Amendment, which prohibits states from treating people unequally. And Amendment 5, the Fifth Amendment, Due Process Clause, which is interpreted as providing the same. However, the most important thing to remember there, we've talked about this before, is that the amendments, 14th that applies to the states, 5th that applies to the federal government, only apply to the governments. So it doesn't apply to an employer who's not a government employer. It doesn't apply to a private school, for example. So we can't rely, in most instances, on the Constitution. So what we rely on is Title VII of the Civil Rights Act, which was passed in the 1960s. And that was on the basis of the Commerce Clause from the Constitution. Okay, so Title VII prohibits discrimination in employment on the basis of race, sex, color, religion, and national origin. It applies to employers involved with interstate commerce. Why? Because that's what gives the government, the federal government, the power to enact such a law. With 15 or more employees, labor unions that operate hiring halls, employment agencies, and state and local governing units or agencies. In addition to prohibiting religious discrimination, employers must reasonably accommodate an employee's religious practices. So remember that with discrimination, there is acts of discrimination, treating people differently. Then there's also situations where employer or an individual has to provide accommodations for somebody for example, their religion. Okay. So the Title VII gives a right to sue a entity for violating the provisions of Title VII, but it's also an administrative program through the EEOC, the Equal Opportunity Employment Agency, or Equal Opportunity Commission. Okay, so that's a federal agency, and they are responsible for investigating violations of the law, and they monitor compliance with Title VII. If you have a complaint alleging discrimination, you have to file a claim with the EEOC before you can bring a lawsuit. The EEOC does not, however, take all cases. They only take priority cases. If they look into your case and they find discrimination, then what they will do is try to get the parties together and resolve the matter either through reinstatement, damages, or whatever. If not, then the EEOC will bring a lawsuit against the employer or whoever it is discriminating. If not, then they give you a letter authorizing you to go to court, saying that you've exhausted your administrative remedies and you can now go to court. So there are some limitations on class action lawsuits in that context. So what kinds of discrimination are we talking about? Intentional discrimination by an employer against an employee is disparate treatment discrimination. To make out a prima facie case, that is the elements of a case of intentional discrimination, the plaintiff has to be a member of a protected class. You have to be black, or you have to be a particular religion that's being discriminated against, or one of those protected classes we talked about. You have to apply for and be qualified for the job. You have to be rejected by the employer, and the employer had to have sought other applicants. Once you've proved these elements, then the burden shifts to the employer to present a defense and evidence supporting that defense. It also prevents negligent discrimination under Title VII on the basis of race, color, or national origin. So if the employer has a policy that discriminates and is illegal, they have to demonstrate a substantial relationship to a realistic qualification for that job. The law also prohibits reverse discrimination. That is discrimination against members of a majority group, such as white males. Okay, so a little different direction right now. If you do have a claim against a government entity, the Constitution itself is not under the law a authorization to sue the state governments. In order to do so, you have to point to a statute, and that statute is 42 U.S.C. Section 1981, which gives a cause of action against individuals who have had their rights and privileges under the Constitution denied by that state. So it only applies against state and local governments. With regard to religion, employers have to reasonably accommodate the sincerely held religious practices of employees, unless to do so would cause undue hardship to the employer's business. So for example, with Muslims who pray, 5 times a day, providing a few minutes for the person to pray and a space where they can do their prayers would probably be, in most instances, considered a reasonable accommodation that an employer would have to provide. Okay. Discrimination based on gender. Employers are prohibited from classifying jobs based upon gender unless the employer can prove gender is essential to the job. Okay, so my usual example of this is if you have, for example, a fancy hotel, and in the lobby of the hotel you have a very, very fancy bathroom, and you have one for men and one for women, and in the bathroom you have an attendant who hands out hot towels and other conveniences. To require that person to be of the sex that that bathroom is designated for is probably essential to that job and would not be found to be illegal discrimination. Pregnancy discrimination is also protected, including childbirth and related medical conditions. We're not going to go into all the requirements of that. It's not a complete cause of action. So there are some areas where employers can discriminate. Alright, so we're going to stop there. We'll pick up with this slide on part 2 of chapter 21.